Okay, so. Right. So Mr. Dagger-Margosian, we'll wait a minute, but Mr. Babino was here. So maybe he went to the restroom or outside to smoke a cigarette. So we can wait a minute for that. Okay, so that's that one. In the matter of people of the state of Michigan versus Archibald DePriest Terry, file number 2023-21472FH. We did announce this while we were off the record, but Mr. Terry failed to appear. We'll issue a bench warrant for his arrest, and we set bond in the amount of $11,971. Miss Underwood. All right, so Mr. Rmer, you ready for him to be brought up?
I am ready for Mr. Rmer.
And then
we have Mr. Gonzalez Rodriguez.
No. So I can call it, we'll get an adjournment. All right, this is in the matter of, Mr. Gonzalez wasn't here, just the one. All right, in the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez, on number 23-21565FH, Rhonda Underwood appearing on behalf of Mr. Gonzalez Rodriguez. I have Alexander Bayonetto appearing on behalf of the people. Mr. Bayonetto, was a writ done to bring him here today?
I believe so, Your Honor. I see a note that does indicate that MDOC confirmed his attendance today.
Yeah. That didn't work out. All right, so I'm going to adjourn this to September 11 at 8:30 in the morning. And Ms. Adams, can we do the notice on that one?
Okay.
In person. I was gonna make Mr. Bayonetto do it, but they did the writ. So, all right, so we'll set that one out to September 11 of 24 at 8:30, and we'll send a court notice to MDOC with, and then Mr. Bayonetto, you'll do the writ.
Yes, Your Honor. I'm putting a note in the file right now.
All right, excellent. Thank you. Okay, so I have Mackenzie Miller.
Mr. Bayonetto, do you know if a plea agreement amended has been prepared on Ms. Miller?
Looks like there was a plea agreement sent to you. I don't see an amended.
Amended plea agreement or amended information?
An amended information, sorry.
I'll have to check what the status is of that when I go back to my machine.
Okay, okay.
If we can take care of Mr. Rmer first.
Yep. Sir, what's your name again?
Mr. Babino.
All right, so can you step back, please? Mr. Babino, why don't you come on up? All right, Mr. Dagger-Margosian, there it is. Step up to that podium. This is in the matter of the people of the state of Michigan versus Brandon Joel Babino. Somebody came from Louisiana or from Canada? It's French, anyway.
Oh, yeah.
24-21851FH. And Michael Dagger-Margosian appearing on behalf of Mr. Babino. And I have Mr. Bayonetto appearing on behalf of the people. Okay, so I do have a note from Darren Coast dated August 5 of 2024. On April 5 of 2024, Mr. Babino was ordered to do 2 times a week drug testing as part of his bond conditions. He got out of Jackson County Jail on June 14th and never set up for testing. Mr. Babino, I am going to order that you have a test done today.
That's fine.
And then you need to speak with Mr. Coast today, and you have to set that up. I know you live in Jackson, so you can set it up in Jackson, all right?
Okay, yeah, that's.
Okay, so when we're done here today, Mr. Coast will meet you in the hall. Okay, so Mr. Dagger-Margosian, how do you wish to proceed today on behalf of Mr. Babino?
Your Honor, I was trying to get get in touch with Mr. Babino. I was unsuccessful in that, but I can relay what the plea offer is, and I believe it's what him and I had talked about, what we were trying to accomplish anyway. So just for the court and Mr. Babino, the plea offer in speaking with Ms. McClure on this matter is, and I think the court should have an amended information. The plea offer is that Mr. Babino would plead guilty to a reduced charge of controlled substance possession, the four-year felony. In exchange for that, it would be a dismissal of the drug doubler enhancement. Further, there'd be an agreement for no upfront jail. There is not an agreement for 7411, nor is there an agreement for 771.1. And lastly, both myself and Ms. McClure would be okay with a probation transfer to Jackson if allowable.
Okay, so plead guilty to the count 2, dismiss count 1, and then no upfront jail. Is that what you said?
Correct.
Okay, I also have a motion and affidavit to show cause for failure to set up the drug testing. So, Mr. Coast, if you could come now, do you mind going to do a drug test now?
Well, that's fine.
If you're clean, I'll dismiss the contempt of court. If you're not, we'll proceed on it. Is that all right, Mr. Dagger-Margosian?
Yes, Your Honor.
All right, so Mr. Coast, I'm gonna have him step out in the hallway and meet with you, and then we'll come back in. All right, Mr. Babino? All right, thank you. All right, so let me get your file. And you are Mr. Rmer?
Yes, I am.
All right, you want to go step up to the podium?
All right.
All right, so Miss Underwood, this is in the matter of the people of the state of Michigan versus Mario Cornelius Rmer, file number 2023-21339 FH, and Rhonda Underwood appearing on behalf of Mr. Rmer, and I have Alexander Bayonetto appearing on behalf of the people. So, Miss Underwood, I know that you had time to speak to your client, right?
Yes.
And how would you like to proceed today?
Your Honor, unfortunately, the independent has not been completed yet. So I left a message for the doctor, and I will get some update on when that is going to occur. But we would ask for probably another 60 days, Your Honor, to put this out so we can
Get
get
that.
that.
Okay, and where are you currently at?
I'm still in Marquette.
Marquette, okay. All right, okay. It's a great place to go on a vacation. You can go visit them. All right, so 60 days would take us to October 16th. Would that be all right?
October
16?
Yes,
All right,
thank you.
and you'll do the stip in order to adjourn?
I will, Your Honor, with Mr. Bayonetto's permission.
Yes,
All right.
that's fine.
Mr. Bayonetto, could you do it?
And I think I've asked before, do you want it early in the morning or you want it later in the day or in the morning? I could do like any time from 8 to 11.
Morning's fine.
Okay, so we'll set that at 8:30 in the morning. So Mr. Rmer, hopefully they'll get a hold of you at the facility and be able to do that, and we'll get the report back and we'll see you back October 16th. And you want to come in person, right?
Yeah.
Okay, so we'll have you back in person. Mr. Bayonetto, you'll do the writ of habeas corpus, correct?
Yes, Your Honor.
Okay, so
In
we are all
person,
set.
correct?
Yes, sir. All right, thank you.
Thank you, Your Honor.
Oh, yep, thank you.
And I'll be,
There's a filtered water machine right out in the hallway. Okay.
I'll just go back and check on Ms. Miller, Your Honor.
Okay, and then let me check. Mr. Wolthius is in jail, so I'll
Oh,
line.
we can do that now too.
I don't have him, but I'll call, but I can do Rmer because Shane Rmer.
It's a motion, Your Honor.
Okay, okay, just go check on this one. All right. Everyone's testing.
Tails, Rick.
Hi, this is Judge Anselone. We are ready on Mr. Wolthius.
Okay, we'll get him going.
All right, thank you.
You're welcome.
Water out of the faucet does not taste good, so.
You have a good day, Judge.
You too. Have a safe drive back.
Yeah, I gotta go right back up Thursday, so.
Bye, thank you. So.
Is Michael Jackson adjourned, do you know?
Yes, I'll put that on record. Miss Adams, did we have a date for Mr. Jackson?
We do now have a date. It is September 4th at 8:30.
All right, so I'll put that on the record. So in the matter of the people of the state of Michigan versus Michael Jackson, file number 2024-21853FH, 24-21854FH, 24-21870FH, and 24-21871FH. Those matters have been adjourned to September 4th at 8:30 in the morning. So, you here this afternoon, Mayor?
Yes.
We also have a civil lawsuit against P. Diddy, Sean Combs. That's at 2:30.
You think he'll appear?
He was served.
Sweet.
I know.
Person.
No. Yeah, he was personally served. Sean Combs was, so that's at 2:30. All right, so we're just waiting for Miss Underwood and Mr. Babino. So I'm going to step off the bench for a moment. Please.
Carry anything?
Is Miss Montalvo at the jail, Becky? You can sit him. Or is she in holding?
No, I think that she turned herself in the clerk's office and they told her to go in the courtroom. Was my understanding.
I don't see an Autumn Montalvo. Did
Maybe
they
they
take
took her in lockup.
Autumn in custody? Is she in lockup?
I don't know.
Can you,
I'll ask Miss Montalvo.
Autumn Montalvo? Yep.
She has a felony warrant. I hope she's in custody.
She turned herself in this morning.
I know, but I hope they took her in custody and didn't just tell her.
I know they took her into custody. I just don't know. I don't know if I hope they did.
Okay.
Okay, I'll let the judge know. Thank you. Custody.
Okay.
The judge.
Is the judge gonna be gone for a while?
She's just taking a couple-minute recess, Sam.
All right, I'm going over to Old Savers Court.
Okay.
No, you're not.
Uh-oh. Got it.
Tell him, John.
Oh.
Crazy day today, Mary.
You've never worked in district court.
Yeah, I did.
Did
Yeah, I covered for Bob once with Judge Shadler. Yeah, it was crazy down there too, but state day.
Yeah.
Yeah. It's pretty great.
Yeah.
Different animals.
Yep, this is a piece of cake compared to that.
Yeah, I mean, we're so short, right, back and forth. No, that's holding cells are full and they're getting fuller. And if you have enough people to bring people, you know, so,
Back and forth.
yeah. There were 10 people short at the jail. There are 4 people short at the county. But like Jeff Gilbert says, they'll hire 2, 2 will leave.
Yeah.
Right there. Wanna just put over on the side over here. Thanks. Bill.
Yeah.
All rise.
Miss Montalvo? Okay.
Yes. Yes, ma'am.
I couldn't see you over the monitor, sorry. All right, you can sit down, thank you. All right, so stand at the podium. All right, this is in the matter of Mr. Dagger Margosian. Oh, you're not on this anymore. All right, so this is in the matter of the people of the state of Michigan versus Autumn Nicole Montalvo, file number 24-21716FH. Ms. Montalvo, it's my understanding you turned yourself in this morning. Is that because your sister told you you had a warrant?
Jennifer did.
Jennifer did? Okay. And you're talking about Miss Walsh. All right, so we are here today on a request and warrant for probation violation. So Ms. Montalvo, it alleges that you violated term 21 of your probation terms, and that on May 17th of 24, you were sentenced to a term of probation, which included a condition of what, no contact with either an Aaron Pickle or a Justin Bowers. And the allegation is on July 30th of 24, you violated that condition when you were within 500 feet of them.
No, I've never.
Oh, hold on. So a violation of probation, this is a 2-year felony, so it could result in up to, if you were found guilty or pled guilty, up to 2 years in prison. Do you understand that? Is that a yes? Okay. And you do have the right to have an attorney represent you on this and all subsequent hearings. Would you like an attorney appointed to represent you? All right. So Ms. Walsh, do you have any more information about that allegation? Was it like at Walmart, Meijer, or like where was the?
Hold on just a second. It was on. It was on 541.5 South Center Street. She allegedly was watching some action that was going on that street.
That was my sister's.
That's your sister's house?
No, my sisters were watching. My sisters told me about it. And they said that.
Okay, so
Aaron
hold
had
on,
thought
hold
that I
on.
was there.
All right, so, okay, so Ms. Walsh, she's been on probation since May of 24. Is that correct? And
Yes,
has she been doing well on probation?
she's done okay. She hasn't had an appointment.
Okay, okay, okay. So, okay, so I'm gonna enter a plea of not guilty. Is that where Aaron Pickle and Justin Bowers live?
I'm assuming so. I don't know. Last I knew that they were living in Morenci on Locust Street.
Okay, okay, so what I'm gonna do, all right, so what she's saying, Ms. Walsh, is it wasn't her, but she's requested court-appointed counsel, and I need to appoint that. So she turned herself in. I've arraigned her. I've entered a plea of not guilty. I'm going to give her an extremely strict warning. Is there any objection to releasing her today?
No.
Okay. There wasn't any allegation of physical contact, correct?
Yeah.
Just.
There wasn't any direct contact that I'm aware of.
Okay. So Ms. Montalvo, I'm going to release you on a PR bond today. I'm going to give you a court-appointed attorney, and Ms. Underwood's super busy this morning. So I'll try to get her to talk to you this morning. So I'm going to release you. They'll take the handcuffs off you, but then I want you to have a seat here, okay?
Okay.
And stay in my courtroom.
Okay, could I get a court-appointed attorney other than Miss Underwood?
I don't control that. So
Okay.
Ms. Underwood is our court-appointed attorney that picks up our bucks. So
Okay.
so they have a chief public defender, and that's their job. So, all right, so I'm gonna release you on a PR bond right now so they can release you, stay in my courtroom. And Miss Underwood will talk with you this morning, okay? Okay, and Miss Walsh will come back to her when Miss Underwood has time to talk to her, okay?
Okay.
All right, so I have a seat, thank you. Mr. Dagger Margosian,
Your Honor, on Miss
Babin.
on Miss Montalvo, I'm happy to step in if the court wants to handle that right now.
I would. So she's released from custody. Show me your hands are free. Okay. So step out in the hallway, go to the left, and there's a podium with a device on it. Are you done with her? Is she all set?
Yeah.
Okay. Log into Zoom. It has the instructions there. Log into Zoom, and I'll put you in a breakout room with Mr. Dagger Margosian. Mr. Dagger Margosian, Miss, we sent that information. Miss Adams, did we send the information to the PD?
We did, but I just forwarded it to Mr. Dagger Margosian as well.
Okay. So who do I have joining me from the jail?
I'm Stephen Walti.
Okay, so we're here. Miss Underwood's got a couple cases going right now. So we'll be with you. And so you have Rhonda Underwood, you have Rhonda Underwood, he has Rhonda Underwood. Let me go check on. Okay, other than that, Mr. Dagger Margosian, do you have anybody?
Just Mr. Babino. Your Honor.
Oh, yeah, he's out. We had an inmate file a civil lawsuit against Sean Combs, Mr. Dagger Margosian.
Yeah, we got all the celebrities. I heard Michael Jackson, P. Diddy. We got a star-studded docket today.
Yeah, but they perfected service, so I have a motion on that today, so. That's it, like 2:30 or something, so.
Is
Okay, I'm going.
is the attorneys, are they gonna play like a walk-up song like in baseball, like a Peabody?
know.
Yeah.
I don't know. We're not allowed to play music in the courtrooms though. There's this really good band out of Detroit that I like, and they play Christmas in jail, and I always thought that would be a good one to play for like the Friend of the Court show causes. It's the Howling Diablos out of Detroit. They're so good, but I'm gonna go check on Rhonda. Logged in. I don't think they logged in yet. So, okay, let me check. Zero.
You talked to the judge, Rhonda?
Hmm?
The judge was kind of looking for you.
I'm sorry?
Did you run into the judge? She was looking for you, kind of. The judge, do you talk to the judge?
Which one?
Judge Ansel?
Oh, no, I'm sorry, which
Okay.
case?
I don't.
Oh, I think we have Mr. Walti.
Yeah, judge, come on. All rise.
All right, Miss Underwood. All right, so Mr. Dagger, you can sit down. Mr. Babino is being tested right now. So, who do you want to start with?
We can start with Mr. Walti, Your Honor.
Right. Okay, this is in the matter of the people of the state of Michigan versus Stephen Richard Waltice, file number 24-21734FH. This is a date and time set for pretrial. I have Rhonda Underwood appearing on behalf of Mr. Waltice, and I have Alexander Bayonetto appearing on behalf of the people. So jury instructions were due back on July 31st. This is a date and time set for pretrial. There is a trial date scheduled on August 14. But I understand there's an issue, Miss Underwood.
Yes, Your Honor. Unfortunately, we've had some issues. Mr. Waltice, I requested forensic on a case downstairs, Your Honor. We're awaiting the results of that. Mr. Waltice, did the doctor see you last week by Zoom?
Yes,
Yes, he did. So we would be asking.
Did you do a forensic request on this file as well?
I did not, Your Honor.
Because it doesn't apply. You would have to do it on both.
Okay, I will. That obviously came after their later files, Your Honor.
Yeah, so if you did a forensic on the underlying file, then they won't forensic him on this file unless there's a separate order.
Okay.
So you
I
making
think
that?
maybe the first forensic will tell me
Okay.
what I need.
So it takes what, about a month to get a report out?
Probably.
All right, and they came and saw you, Mr. Waltice?
via Zoom.
Okay, okay. So why don't we set this out to like October?
Okay.
And take the trial off the docket?
Okay.
All right. So, I mean, because it's concerning, because if he's found not competent, we don't want to. Okay. I'm gonna write in here. District Court Forensic. All right. So, Miss Underwood and Mr. Bayonetto, I'm going to set this over to October. But Mr. Waltice, if we get the report back from the district court file, Miss Underwood will discuss it with whoever the prosecutor is, and it may have bearing on this case, even if there's not a forensic, which would either require us to request a forensic on my file as well, or the prosecutor can deal with it in an appropriate manner. So I'm going to set this for pretrial. Let's do October 16. So I'll set it for pretrial on October 16 of 24 at 8:30 in the morning. And then I'm going to cancel the 8/14 trial date.
Thank you, Your Honor.
All right. All right. So Mr. Walti, good luck and we'll see you back in. But
Hold on.
understand, Miss Underwood may bring you back much sooner, okay?
May
Yes, Steve.
I talk to my
Oh.
attorney for a minute, please?
Not right now because she has a bunch of cases backed up. So, but she will come talk to you, okay?
Like-
All right, thank you.
I have
You're
no
all
idea
set.
what's going on. I'm completely confused.
Okay, we're just waiting to get the report from the doctor that zoomed in with you, okay?
All I'm trying to ask is I was set to tether to my parents' house. If it's all right with my parents, I stayed here because my mom had cancer surgery. Am I still able to tether back to my parents' house since the court said I
That's
was
a
able to?
separate motion I can't address today, so talk to your attorney.
I'll be over to talk to you. I did talk to your dad. I'll be over to talk to you.
Pull the mic down. Pull your mic down. It's way up there for tall people. All right, so Mr. Walti, she'll come talk to you. She did talk to your dad and she'll come talk to you, all right?
Okay.
Okay, thank you. Okay. All right, so, all right, so Mr. Babino, okay, he's out there testing. I had to pick up and Mr. Dagger goes in and took it for you.
Oh,
Okay,
who was that, Your Honor?
Autumn Montalvo.
Oh,
Yeah.
he did?
Yeah, he did.
Okay.
All right, so, and you'll do this step in order to adjourn on Walti's?
Yes.
Okay, so do we want Miss Miller or who do you want next?
Miss Miller, Your Honor.
All right. All right, so this is in the matter of people of the state of Michigan versus Mackenzie Ricole Miller. We have two files, 22-20935FH, and we have 24-21725FH. One is a violation of probation, if I am correct.
Probation, yeah, that's.
Yeah, and one is a pretrial. I have Rhonda Underwood appearing on behalf of Mackenzie Miller, and I have Alexander Bayonetto appearing on behalf of the people. So, were you able to find the information you needed?
Well, the plea offer, Your Honor, is that Ms. Miller would plead guilty on file 21725FH to a reduced charge of larceny under $200, Your Honor.
Okay, so repeat the file number again.
I'm sorry?
The new file, 21725,
Yes,
plead guilty to what count?
to one count of larceny, to an added count of larceny under 200, Your Honor, a 93-day misdemeanor. She would also plead to 93-day misdemeanors on district court files 240107 and 232530.
Miss Montalvo, you can come back in.
Okay, thank you. Can I
You're
just shut
welcome.
this off?
I got it. Don't worry about it. Oh, sure did it. Good job. All right, so she's gonna plead on some district court files and then there's going to be an amended information on file number 24-21725, adding a second count. So count two, larceny less than $200, which is a 93-day misdemeanor. Is that correct, Mr. Bayonetto?
It is, Your Honor, yes.
All right, and then she can plead to the violation of probation.
The violation of probation, I believe Ms. Miller will plead guilty to an appropriately worded one, Your Honor, since the one Alex is alleging.
Ms. Walsh, can we amend that to say that the defendant pleaded guilty to one count of larceny less than 200? You're muted, by the way. I can't hear you if you're talking to me.
I
Yes.
apologize, Your Honor. Ms. McClure's getting ready to come up to finish the docket. I have an exam at 11.
Oh, I guess it's almost 11. Okay. All right, thank you. But is that a correct recitation, please, Mr. Bayonetto?
It is, Your Honor, yes.
All right, she's on her way right now?
She is on her way up, yeah. I can finish the plea. It's not a problem.
So, Ms. Miller, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, so you've heard, you can put your hand down. You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty on your new file 24-21725FH to account to larceny less than 200, which is a 93-day misdemeanor, as well as to an amended violation of probation, which would be pleading guilty to larceny less than 200. And then the second one was failing to report police contact to your probation officer. Okay. Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Is that a correct statement, Mr. Bayonetto and Ms. McClure?
It is, Your Honor, yes.
Okay, and Ms. McClure is here if you need to go, Mr. Bayonetto.
Okay.
Okay.
Thank you, Your Honor.
All right. So, Ms. Miller, if a guilty plea is accepted on these two counts, there will be no trial. This means that you will be giving up your rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them, okay? Ms. McClure, you can sit up here.
Did he just log off?
He just logged off,
Okay,
so
sorry
you're
about
it
that.
now. All right, you have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your pleas are accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Okay, and do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? All right, can you speak up a little bit? And you can approach the microphone a little bit more too. She doesn't bite. All right. And let's see, I don't know if I said this, but if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States or of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
I don't.
All right, so we're gonna start on the new file. So on file number 24-21725FH, how do you wish to plead to the charge that on or about November 19th of 2023? Where does Alex Purdue work?
Lenawee County Sheriff's Department.
All right, well, that doesn't help me then. I don't have, it just says Lenawee and Lenawee. I don't know why.
What charge is it?
B&E of a motor vehicle.
I believe Adrian Township.
Okay, so did this occur in Adrian Township in the county of Lenawee?
Yes.
Okay, so you're in Adrian Township in the county of Lenawee.
Yes.
All right, and how do you plead to the charge then that you committed the offense of larceny? Is it larceny from a motor vehicle less than 200, or just larceny?
Just larceny.
Larceny less than 200, guilty or not guilty?
Guilty.
All right, and then on the violation of probation, how do you plead to the charge that you violated, I don't know, it's screen sharing. So hold on. I don't know why it does that. Okay, For some reason, my Polycom likes to share screens just randomly. I don't know why. So how do you plead to the charge that you violated your terms of probation by pleading to the charge of larceny less than 200? Guilty or not guilty?
Guilty.
And then how do you plead to failing to notify Ms. Walsh of police contact within 24 hours? Guilty or not guilty?
Guilty.
Okay. So has anyone made any threats or promises to you to induce you to plead guilty to any of these charges?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Ms. McClure?
No, Your Honor.
All right, so you have to be quiet in the courtroom, so just be quiet for a minute, all right? Is it your own choice to plead guilty?
Yes.
All right, so ma'am, let's go back. So on November 19th of 23, were you in Adrian Township in the county of Lenawee?
Yes.
All right, and at that time, did you steal something from a car that had a value less than $200?
Yes.
Did you know whose car it was?
I don't.
No, and was it money, debit card, what'd you take?
Money.
Okay, all right, and you didn't know whose car it was, you had no right to take it.
Right.
And when you took it, your intent was to deprive the owner of that value.
Yes.
All right, so for restitution purposes, the value with these, if the items weren't returned, you understand you might owe more restitution
Yes.
than $200. Okay. Are you satisfied with the plea?
Yes, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has.
Ms. McClure?
It has.
All right, and then we'll need that amended information on that file.
You do?
So, yeah.
Okay.
Okay, so then on the violation of probation, you just pled guilty to larceny less than 200, is that correct?
Yes.
And then when you had police contact on that day, you did not report it on November 20th to Ms. Walsh, is that correct?
I did not.
All right, I accept that plea as well. They've been given understandably, voluntarily, and accurately. She has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defendant, the defense attorney, or anyone else acting in the interest of any of them. I'm going to refer this matter to the probation department, and I'm going to set sentencing for September 20 at 8:30 in the morning. And do you want to appear in person or Zoom? You're always here in person. Okay, so that'll be in person. So Ms. Walsh is going to do a pre-sentence report for the new case and a probation violation report. So Ms. Walsh, when do you want her to report to you? You're muted. You're muted. You're muted.
She already knows when to come in. Are we doing the pre-sentence if it's a misdemeanor?
Oh, no, you won't. You have to do the misdemeanor downstairs. All right, so you're gonna report to Ms. Walsh as ordered to do the violation of probation. Next Thursday, not today, not tomorrow, but next Thursday, you need to report to the district court probation department because it's a misdemeanor you pled to. And see Mike McCarron, do you know him? So ask to see Mike. He'll set up a time to meet with you to do a pre-sentence report. Be truthful with them about your background, the events that occurred, and then we'll see you back on September 20th at 8:30. Call Miss Underwood about a week in advance and review the PSI with her. Miss Adams, Miss Miller is present. Can I get a notice of hearing for sentencing for her?
Yes, Judge, did we discuss if that was in person?
Yes.
I mean, okay.
It's in
it is.
person. Yeah. Okay, so we are all set. Have a seat right behind you. And then Miss Adams will get that notice. Hold on. Okay. All right, Mr. Dagger Margosian, I have Mr. Coast back on Mr. Babino. Mr. Coast, would you, Mr. Babino,
Yes.
come on up, and Mr. Coast, what is the result?
Judge, prior to the test, I asked him if he was taking any medications. He indicated he was not. He did mention that he took or smoked marijuana this morning, that he has a medical marijuana card, but that he lost his card. That test did return positive for both THC and also meth. He's now indicating to me that he did take an Adderall just yesterday.
Okay, do you have a prescription for Adderall?
No, I got.
Okay, that's all, okay, so, Mr. Babino,
Yes, I was not.
hold on, stop talking, because you're just gonna dig yourself in a hole. All right, so Mr. Dagmar goes in, so he had stated he is not on any prescription drugs or medications at this time. He tested positive for marijuana. I don't have a medical marijuana card. Mr. Coast is gonna need to get that. And then he also tested positive for methamphetamine. Whether you use meth or Adderall is irrelevant at this point. So Mr. Dagmar goes in, I am not going to dismiss the contempt of court. How far did we get in this? I don't even think we took the plea yet, did we?
We didn't. I just outlined what the plea was.
Okay. Okay, so the plea is plead guilty to count 2 with no upfront jail, which is a 4-year felony and carries up to a $25,000 fine. And the contempt of court is that when he was released from the Jackson County Jail, he failed to set up 2 times a week drug testing. So those are the 2 allegations. So Mr. Babino, do you understand the plea offer is a plead guilty to count 2, which is a 4-year felony? And the contempt of court can carry up to 93 days in jail. Do you understand that? Okay. And did you have enough time to talk to Mr. Dagmar Gosian? You haven't talked to him yet? No. Do you want time to speak with him, Mr. Dagmar Gosian?
I would like to. I don't.
He wants to talk to you. All right. So I'm going to send him out in the lobby. Or Mr. Dagmar Gosian, do you want me to set this for another day? I can do that.
The lobby is probably fine. I'll speak with him, and if we need a different day, we can set it for a different day.
Okay. So Miss Adams, I hate to bother you. Will you walk out with Mr. Babino just to make sure before it was spinning? So just make sure he can log on in the hallway. So Mr. Babino, go out in the hallway. You're going to log on to a Zoom device in the hallway to talk to Mr. Dagmar Gosian, all right? And then you'll come back in. Okay, so now, what do we got? All right, I got it. I'm gonna open up that breakout room. So,
okay.
All right, so I'm gonna, Mr. Dagmar goes in, Mr. Babino, I'm gonna open up a breakout room. You just need to click on join the breakout room. You see where the button popped up? It says join breakout room. Perfect. Bless you, bless you, bless you. Alvin Graves, you ready on him?
It's in rehab. Do we have?
Can we put it on the record?
Yeah.
Okay.
Last time.
Okay, so this is in the matter of the people of the state of Michigan versus Alvin D. Graves, file number 23-21428FH. This is a date and time set for pretrial. There was a June 20. I don't have a stip in order for today. Just, I don't know if it's in back or it's in the system. Just to let you know, I have a stip in order to June 26th, but not to today. Mr. Coach, do you have an update on Mr. Graves?
Judge, last I knew, he was in treatment, left treatment against staff advice. I mean, I actually drove out to his residence because he wasn't drug testing, spoke to his mother. She was going to relay the message for him to get a hold of me.
I have not heard from him.
When was that?
So he did not appear on the June 26th date, and that's when we received the information that he had left Dawn Farms, and since then has not been located. So I think today maybe we put out a notice, but didn't do a stip and order.
Okay.
To see if we could locate him between June 26th and today.
Okay, so, I don't see a notice of hearing for today's date to even give him notice to appear today in my file. Do you have one that was signed by the people?
No, we didn't do a stip and order because you said you were gonna issue a bench warrant and send a notice. So I was wondering if you had in your notes that you did issue a bench warrant. I have that court issued a bench warrant and set bond at 25,000 cash. We'll do notice for August.
Yep, it's just a couple pages back. So on July 1, I did an order, said that the stipulated order was never provided for the June 26th at 24 hearing. Oh, so.
So you quashed the bench warrant.
I quashed the bench warrant. Then I got a stip and order for the June 26th hearing afterwards. Because he didn't appear for June 26th, but we realized nobody did a stip and order and sent notice of the June 26th hearing. And then the stip and order was actually provided to the court on July 3rd. So
So it looks like we did a stip and it was sent over to the prosecutor's office, which I don't know what happened there.
for today's date,
For the June case, June date. Of course, that's what the notes say. And then it looks like you quashed the bench warrant. My understanding, he was still in treatment, but he's not in treatment anymore.
so the one thing we did have is a motion affidavit in order to show cause that was filed by Mr. Coast, which was mailed out, giving him notice to appear on June 26th. So I don't know, at this point, he's still not here, so.
Judge,
And he
I've
hasn't-
not
and he's had not-
and he's done 0 drug screens.
Yeah, and he has not contacted Mr. Coast, so I am going to issue a bench warrant for failure to appear, and I'll set bond in the amount of 25,000 cash.
And I do have a stamped stip and order to adjourn the pretrial from July 1st to today. So if the court needs a copy of that.
It's in the process
Okay,
somewhere. It's
so
probably
we have-
coming to my file.
It was signed on July 1st.
Okay. All right, so if you hear from them, let us know. We hold that for 24 hours.
Okay.
Or 48 hours. Okay.
Thanks, Judge.
All right, so that takes care of Mr. Graves.
Did you say cash or cash? Did you say cash?
Cash. Always cash. All right, and you have the sentencing?
Did they bring him over? That's all I'm gonna ask.
He's here.
He's here.
Hold on.
That's all I want.
I thought you requested to be on Zoom.
He wanted Zoom.
Yeah. Oh, when I talked to him, he wanted to.
All right, you can go in my jury room if you want.
No, I'll stay here.
You got a Zoom breakout room with him?
I already met with him.
Okay, and he's at the jail. Okay. All right, so we will call the jail and get Mr. Thomas. All right, let's see, Miss Montalvo, you want to come up to the podium?
Hello.
Hi, this is Judge Anselone. I was wondering if I could get Mr. Thomas.
Absolutely.
All right, thank you. I have window 3 open. I don't know if that matters.
Okay.
All right, thank you.
Bye.
All right, so we are back on the record in the matter of, back there. Autumn Nicole Montalvo, file number 24-21716FH, Mr. Dagmar Gozzian. Thank you for taking an opportunity to speak with Ms. Montalvo. How would you like to proceed today?
Your Honor, in speaking with Ms. Montalvo, as well as hearing the court go over the allegations and now receiving the allegations, I'm asking the court to schedule this violation of probation for a hearing, please.
All right. So, Ms. Walsh, how long will you need to get witnesses?
Not long. There will probably be.
I mean, I know I won't have anything in the super near future because I won't. It's probably gonna have to be September.
I will have. Let's see. One, two. I will have 3 or 4.
Can you list those for Mr. Dagger Margosian so you can write them down?
It will be Aaron Pickle, Justin Bowers, Savannah Bowers, and one more, but I need to get the name.
All right, can you email that name to Mr. Dagger Margosian when you get it?
Yes.
Okay, so I apologize. We are kind of backed up a little bit. In person continue here 3 hours. I can do 11:30, 12:30. I could do September 20th at 1:30. Mr. Dagger Margosian.
Your Honor, I am in trial that day.
Okay, not a problem. I could do Wednesday, October 2nd at 11. Is it, you think an hour or 10:30, an hour and a half?
At what? I'm sorry, what time?
October 2nd at 10:30. It's a Wednesday.
Let's see.
Or I could do actually October 3rd at 9 a.m.
That's scheduled as the last day of that trial.
Friday, no, I have to do a wedding that day. And then I'm gone. And then it's got interpreters, that'll take longer. Termination trial. I'm sorry, we have like so many different things going on. Then I have there's so many jury trials coming up. Hold on. Settles. Got a bunch of jury trials. Okay, so I'm looking at October 24th from 8 to 9:30.
That's fine, Your Honor. Thank you.
Okay, I'm sorry. We will do this 8 to 9:30. And do you want to be in person, Mr. Dagger Margosian?
Yes.
Probably be easier. All right, so this is going to be in person. And Miss Adams, could I get a notice of hearing from Miss Montalvo for October 24 at 8 a.m. for an hour and a half?
Yes.
Okay, so not the worst of box, okay, but there's a couple things. Get a job. You got to get a job.
I have a job.
Good. And then you can do volunteer work to pay down your fines and costs. Ms. Walsh can help you with that. If you see them, run the other way, okay?
Will I be able to bring in my own witnesses for
Yeah.
the hearing?
Yep.
Including the officer that spoke to my sisters that were there?
Yep, so you get the names of those witnesses to Mr. Dagger Margosian.
Okay, one of them would be when officer, so
You get those names to Mr. Dagger Margosian and he'll subpoena them.
Okay, awesome.
Okay, so you need to call Mr. Dagger Margosian's office and set up an appointment to meet with him in the next 4 to 6 weeks. Okay? You have any questions? All right, so we released you on a PR bond and we will see you back on that day, okay? And remember to report to Ms. Walsh as ordered.
Like right now?
No.
When I'm supposed to report?
Normal report date. All right, thank you. Thank you, Mr. Dagger-Margosian.
Judge, can you have her wait
Oh,
to sign the
wait, you gotta get
paperwork?
your notice. Yeah, just have a seat right between those two attorneys. All right. Okay, so, Mr. Dagger-Margosian, you ready for Mr. Babino?
Yes, Your Honor.
All right, come back up, Mr. Babino. Step up to the podium. All right, so Mr. Babino, you have now had a chance to speak with your attorney.
Yeah.
All right, Mr. Dagger-Margosian, how do you wish to proceed on behalf of Mr. Babino?
Well, Your Honor, there's two matters to take. On the underlying case, we are ready to enter a plea to the plea as outlined. Regarding the contempt of court vis-a-vis the bond violation, I'm asking the court to set that matter for a hearing. I've also, there's sort of a larger issue of if that is indeed qualifies as a contempt of court. I'm happy to address that at the hearing as well.
Okay, all right. So he's gonna plead to count 2 with no upfront jail.
Correct.
And so you're arguing that violation of bond conditions potentially is not a contempt of court?
Correct. I agree that if the facts are laid out that it is a violation, it certainly would be a bond violation. I just don't know if that's if it qualifies as the greater quote unquote contempt of court. I know that district court does it. I was unaware that circuit court is starting to do these, but I can address that at the hearing.
Okay, we've always done these, so okay, we can address that later. Ms. McClure, any?
I mean, I thought a bond violation was a contempt of court, so I'm not sure what that means.
I'm gonna have him brief the issue.
Okay.
Okay, all right, so Mr. Dagger-Margosian, all right, so he's gonna plead today, and the plea offer is plead to count 2 with count 1 being dismissed and no upfront jail.
Yes, and we had talked about doing no upfront incarceration, which I will stick to even with the bond violation. I will say though, if he is sentenced on contempt of court to a couple days in jail, that that's, I don't believe a violation of the plea agreement that he get no upfront incarceration on the underlying.
Okay, so she's saying no matter what happens on the contempt of court, whether we continue with it or not, that doesn't impact the plea offer that she made, Mr. Dagger-Margosian.
Thank you.
Okay, I'm gonna raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yeah.
All right, so Mr. Babino, the alleged violation of your bond conditions is you failed to set up 2 times a week drug testing after getting out of the Jackson County jail on June 14th of 24. So I'm gonna enter a plea of not guilty on that. Do you understand that?
Yeah.
And then Mr. Dagger-Margosian is gonna do a memo for me on whether or not he believes that is in fact a contempt of court. I'll provide that to Ms. McClure and she can respond. All right, so then on the underlying file, Mr. Babino, you heard your attorney and the prosecutor state that the plea offer in this matter is to plead guilty to count 2, controlled substance, possession of, it doesn't, look at the following information. It's just, I'm assuming it's methamphetamine, but it doesn't say. So it just says possess less than 25 grams containing the controlled substance, other narcotic. But I'm assuming.
Oh, yeah, so it would just, the factual basis would be that if he possessed a controlled substance or another narcotic that is a Schedule 1 or 2.
But it's a methamphetamine.
It was methamphetamine reduced to that charge.
Okay, okay.
Yeah.
So do you understand the plea offer is to plead guilty to controlled substance, possession of cocaine or methamphetamine less than 25 grams?
Yeah.
Okay, and you understand the maximum penalty of that offense could be up to 4 years in prison, but there's a plea offer that you would not do any upfront jail.
Yeah.
Okay, speak up for me, okay?
Yes.
Are you satisfied and is it your intention to plead guilty to that count?
Yeah.
Okay, are you satisfied with your attorney and the advice that he has given you?
Yeah.
All right. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Dagger-Margosian?
Correct, Your Honor.
Ms. McClure?
Correct.
And as far as you're aware, is that correct?
Yeah.
Okay, all right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yeah.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
Do you have any, if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization? Do you have any questions about the rights that I've given to you?
No.
All right. Sir, how do you wish to plead to the charge that on or about December 4 of 2022 in the city of Hudson in the county of Lenawee that you did commit the offense of controlled substance possession less than 25 grams of another narcotic schedule 1 or 2? Guilty or not guilty?
Yes.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this
No.
charge? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Dagger-Margosian?
No, Your Honor.
Ms. McClure?
No.
Oh, okay. Has your attorney, other than the plea agreement, promised you any sentence or estimated what your sentence will be in terms of fines, costs, probation?
No.
All right. Is it your own choice to plead guilty?
Yes.
All right. So, Mr. Babino, on December 4 of 2022, were you in the city of Hudson in the county of Lenawee?
Yes.
And at that time, did you have in your possession, for the purposes of the plea, methamphetamine?
Yes.
All right. Did you know it was methamphetamine?
No.
What'd you think it was?
Cocaine.
Okay, seems to be a lot of that going around today. So, so you thought it was cocaine, but you later understand that it turned out to be methamphetamine.
Yeah.
Okay, which could have killed you.
Yeah.
Okay, and you had no legal right to possess even what you thought was cocaine, much less methamphetamine.
No.
Okay, and was it less than 25 grams?
Yes.
Okay, are you satisfied, Ms. McClure?
Yes.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Dagger-Margosian
Yes, Your Honor.
and Ms. McClure?
Yes.
All right. Ms. Adams, I'm going to set this for September 20th. So can I get a notice of hearing for in person on this one too for him? All right.
Yes.
The court has, I accept the plea. It's been given understandably, voluntarily, and accurately. He has full knowledge of his rights. He has competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. We are going to set this for sentencing on September 20th at
Your Honor.
8:15.
I'm sorry, the September 20th date, that date doesn't, that's the trial date, I'm sorry.
Ms. Adams, do I have September 26th or 27 available?
I believe you have the book, Judge.
Those also don't, is there any time in October, maybe the same day as what we just said, maybe?
No, because that's before my recovery court, so hold on. How about I could do 8:15 on October 11.
I'm in a different trial, unfortunately. That trial may wash out, I don't know.
What time is your trial?
9 a.m.
Okay. I can do. I have, oh, no. I can do October 18th at 8:15.
That is good. Thank you, Annie.
All right, so Ms. Adams will change that to October 18th at 8:15 in the morning. So.
Oh, I'm sorry, I was just gonna check, are conditions staying in place until?
Oh, I'm gonna talk about those.
Okay.
Yeah. So, Mr. Babino, I'm gonna require that to be in person. So you gotta come here for that sentencing. And then, today I'm gonna send you over to the probation department to check in. They're gonna give you a packet to fill out and a day to come back in and meet with them, okay? So, the not guilty plea was entered on the contempt of court. You're gonna talk to Mr. Coast today and you're gonna set up drug testing.
Yes,
And you're gonna go, and if you test positive, I'm gonna issue a bench warrant for you, all right?
yes,
And then you would just sit in jail till sentencing.
yes.
All right, if you don't have a prescription
Don't.
for a medication, it's a crime to use it. Do you understand it?
I didn't know
That,
that.
all right. And then if you have a medical marijuana card, you need to provide that to Mr. Coast.
I'm working on that.
If you don't have it, don't smoke it.
Right. I'm just working on getting the card again.
Wait, you don't have a medical marijuana card?
I do, but I lost the actual physical.
Okay, well, you better get that to Mr.
Yeah, that's-
Mr. Coast.
Yes,
All right, and if you fail to comply, your bond conditions still remain in place. So you need to comply with those. And then if you don't comply with those and get Mr. Coast what he needs, understand, I can issue a bench warrant for you again, you're sitting in jail till sentencing.
yeah.
Okay, anything else, Mr. Dagger Gozan?
Your Honor, a few things. For the contempt of court, is that on the same day as sentencing?
You're gonna send a memo in on your whether or not you think it's a contempt of court. And then once I review those, I'll decide whether or not I'm gonna set it for another day.
Well, that's fine. I mean, I also think that I'd like to argue the facts of the offense itself. So it's sort of a legal argument as well as a factual. So would we have a hearing on 10/18?
So I just want you to submit a brief.
That's fine.
And then Ms. McClure will respond and then I'll review them. If I determine it's not a contempt of court, I'll dismiss it. And if I am not swayed, I will set it for a court date.
Okay.
Is that all right?
Well, sort of. I mean, the reason why I'm pushing back a little bit is because part of the argument that it's not part of the argument that it's not a contempt is that
Okay. All right, I can also just revoke his bond for failure to comply with bond conditions. So I'll wait for your memo and we'll discuss it further, all right?
Okay. And regarding the drug testing, he does live in Jackson. I'm wondering if Mr. Coast would.
Mr. Coast had been willing to help set him up in Jackson. He just never reported. So Mr. Coast will discuss that with him.
Okay. And then lastly, again, him living in Jackson, I'm wondering that at the time of sentencing, if transfer of probation would be available to Jackson.
We automatically do that. So, yeah,
Well,
not a
it's not
problem.
at the time, it's not at the time of sentencing. We have to have it approved through Jackson and
Yeah.
just a process for it that he's gonna have to comply with.
Yeah, we automatically do that, but Jackson may not accept them, but I don't think we've ever had a case where they don't. I don't know.
Right.
All right. Anything else, Mr. Dagger Margosian?
No, thank you.
All right, so Mr. Babino, go talk to Mr. Coast. Thank you. And Becky, did we get him a notice? Yeah. Okay, thank you. Thanks. Rhonda, we have Mr. Rmer.
We need, I think, Miss Wagner for that. I just sent her a text.
Okay. So,
Is that a motion hearing?
okay.
Then yes, I need Miss Wagner.
So I will be back and we'll take about a minute break waiting on that.
What's that? Oh, I'm okay. How are you?
So Phoebe,
Yeah.
I sent you an email on that from Cambridge.
Yeah.
Is that you or is that Alex?
I don't know. I was
Because
trying to
on
figure
the-
that out.
Well, from what I get to see on the call, it shows you. And then you can never tell if you, like, there was stuff missing. And I thought that message came through, I don't know, I couldn't find the message. Like there were pictures missing, and so I
So
sent us
Alex has
stuff.
an active case with that guy as a defendant.
There is.
Okay, I don't
Another
know.
charge. So then they got into it again. Burnt her mailbox up. I didn't know they would burn up and melt and disintegrate like that. Pretty interesting. Or else she did his, I don't know which one. it was. I think she did his. And he was gonna prosecute, and then he decided to not prosecute. He sent it in as co-defendant, co-combatants.
Okay.
Now,
I'll have to look at it more. I was kind of rushed when I was looking at it, so.
Cartel showed it too, but I can't tell if you got someone we sent it in. And then I redid the pictures when we sent it. And I only sent it to you because that's what it showed, but it's not no big deal. It's just sitting there. We're supposed to do something with it. I wanted to move the file off my space.
Okay, I'll take a look.
That's no big deal.
Right.
I think that's.
Right.
I don't know.
Yeah, I do. Days. Okay, all right, well, let's not talk about that. Give you feels. Yes, I do. Yes. I remember.
Have that motion. Same. It's the motion.
Yeah. I did all this spell. Did it spell? Yeah. Yeah, he says, hey, do you remember that time I went to court for contract? He gave me I'm not sure what we're talking about. This was for the misuse. All rise. Where is that?
So. All right, so are we all ready on Tom's?
Yes.
Okay. Wait, we're ready on you. Let's do yours real quick. Okay. All right, sorry about that. Mr. Rmer, you want to come up? Last but not least, Mr. Rmer, but all right, this is in the matter of the people of the state of Michigan versus Shane. You go by Leroy, right? All right. My husband always says, no, I'm Leroy. So Leroy Rmer, file number 23-21665FH, run Underwood appearing on behalf of Mr. Rmer and Amanda Wagner.
Yes.
Appearing on behalf of the people. This is the date and time scheduled for hearing on a motion to quash information and motion to dismiss. So, Ms. Underwood, are you ready to proceed?
I'm ready to proceed, Your Honor, but,
Your Honor, so it looks like this was stamped and received on July 26th. I didn't receive it on my desk until midweek last week, and it wasn't placed on my schedule either. So, but I've reviewed it in the last few minutes, and I think that I would be comfortable responding at this point. I guess I would just ask that if the court has further questions after we're done arguing, that we perhaps set it out so that I have an adequate amount of time to respond to Ms. Underwood's motion.
Do you want a week or two to respond?
I mean, I would.
I'd like to have them in writing for cases of appeal.
Yes, I would prefer that if the court's willing.
Ms. Underwood?
I would leave that to the court's discussion.
All right. Obviously, these motions to quash, if they're denied, I don't know if it would be, can come back on appeal. So I do like when we have things in writing. So, let's see.
Your Honor, just to make it a little easier while you're looking for a date, I don't know if we're able to do it within the next week, but I am leaving for vacation on the 15th and I won't be back until the 26th.
I can do it Mr. Wolfis is off. So I can do this at 11 o'clock on Wednesday, August 14, next week.
11 o'clock, August.
14, after we finish our criminal docket, 11 o'clock.
Thank you.
Miss Adams, could I get a notice for Mr. Rmer for August 14 at 11?
Okay.
So, thank you for your patience. And we will see you back on August 14 at 11. And we're gonna do the notice because I wanna make sure he has a notice before he leaves.
Thank you, Your Honor.
Okay. All
Thank you, Your
right,
Honor.
so just have a seat right behind you and we'll get that notice to you. So we'll wait for that for just a moment. I'm just gonna serve him the notice and then we'll get started on Mr. Johnson.
Actually, they don't have anything on. Nothing. On failure to ID.
Mr. Millar, you sent me a chat at 8:45 and it got buried in all the chats that were coming through for Mr. Tom's.
Sorry, I thought you saw it.
There was like so much chatter going back between the attorneys on one of the juvenile cases, it got kind of buried. Mr. Tom's, are you comfortable appearing via Zoom today?
I guess, yeah. Yeah.
Judge, when I met with him, it was my understanding he wanted to be here in person. The other.
Let me call the case first. So this is in the matter of the people of the state of Michigan versus Douglas Henry Toms, file number 23-21221 FC. The last time we were here, Mr. Toms had released his attorney and we appointed court-appointed counsel. And Mr. Toms looks like was okay at that time appearing via Zoom.
He actually requested to be.
He requested via Zoom, so that's why we had it scheduled via Zoom. Even with your request this morning, I couldn't have gotten him over here because the way staffing is. So, Mr. Toms, we are set for sentencing. As I said, the last time you were here, you requested in person. Are you willing to proceed via Zoom today?
Yeah.
Okay. Now, Mr. Toms, it's my understanding that Mr. Millar met with you and reviewed the pre-sentence report with you. Is that correct?
Yes.
Okay. All right. So I have Salvatore Millar appearing on behalf of Mr. Toms. I have Phoebe McClure appearing on behalf of the people. This is the date and time set for sentencing. Mr. Millar, I show that our office provided the pre-sentence report to you back on July 30th of 2024, and you received that?
I did receive it, what's I think characterized as an updated report, Your Honor. Apparently there was some revisions that were necessary, but I did receive that and I did review that.
So I have a PSI. I don't know if I have an updated report. Did you?
Judge, I don't think it was, the only thing that was probably updated was the guideline scoring. And those just got replaced, so it wasn't an update, it was just a submitted guidelines.
Yes. There was one initially done, I think on the 15th of May, but I don't know that that one ever made its way to the court. The one, there were some revisions done in the.
So I have one dated May 13th. So I have a PSI that was dated. Miss Adams, is there another PSI floating around back there on Mr.
Well,
Thompson?
the updated one still has the May 13th date on it. The only thing that changed, Mr. Jones changed some guidelines and the description of the offense narrative because it left out some of the counts.
All right, so the
I
guideline.
have the updated one.
Okay, so Mr. Jones, and we can object to these in a minute, but Mr. Jones, I have on count one, the guidelines for CSC first degree of 108 to 180. I don't have an updated guideline sheets in the back because mine are signed from the previous date. But did we agree that count one at the time, it may not be today, but I have 108 to 180 for CSC first degree, which may still be disputed. And then second degree was 36 to 71.
Yes.
And then count three child abuse, second degree, 43 to 86.
Yes. So you have the most up-to-date PSI at this point.
I have those handwritten notes on my first page. So what I don't have are the guidelines scored sheets that were updated, I don't think. But
I didn't know they were updated from this. I didn't receive anything updated from the ones you just read.
I have 36 to 71. I don't know, 36 to 71, 108, 20, I guess I do.
Yeah.
Okay, all right. And those were updated when Mr. Bernstein was counsel. So I understand you may have some objections.
I mean, yeah, I'm in an awkward position, Judge, because all I'm doing is reviewing the PSI with Mr. Johns.
Are you, well, he fired his attorney before we proceeded to sentencing and we appointed counsel.
I understand, I spoke to his office, Mr. Bernstein's office.
Okay.
And I mean, we have to go, he has to go forward with the sentencing.
I understand that, but are you?
But I don't have full knowledge of all the workings of what happened here.
Right, but
That's what I'm saying.
I'm just saying you may have objections to the guidelines. I don't know yet. Okay. So Mr. Toms, you had an opportunity to read and review the pre-sentence report with Mr. Malaro.
Yes.
Okay, are you satisfied with Mr. Malaro as your attorney for sentencing and obviously for the limited purpose of sentencing because he wasn't your counsel before and any advice that he's given you?
Yes.
Okay. Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Yeah, Judge, I think my calculations, he should be getting 105 days of jail credit.
That's correct, after the jury.
Okay, so we will update that to 105 days jail credit.
On the first page, personal history, he indicates he has difficulty hearing, as well as some physical health issues, which I'll probably address under the health section.
Okay, I do see that it says heart issues, carcinoma. All right, so we can add language on page 6 under health that he has hearing issues.
Correct.
And what else?
My notes say that he had a heart attack at some point.
Yep, we have that.
Awaiting a stent. And then that, yes, it says cancer, but it's my understanding he has skin cancer. And has been awaiting surgery. In fact, was scheduled, but because of this case was delayed. I think it's on his ear.
All right, so it looks like the only thing we need to add is the hearing issues. Okay.
On page 4 of where it says marriage, he indicates that Sandra Martinez was a former spouse, not a former significant other.
Okay, we can change that.
He does dispute the value of any assets that it indicates. He would object to the vehicle being listed at $15,000. He says it's a 2007 Ford Explorer, which would make it 17 years old. Not sure what condition it'd be in, but I'd be surprised it would be worth that much. And same for the 2012 Dodge Avenger.
Right, and just, how do you compute the value?
Judge, all I can do is provide the information that's been provided to me at the PSI.
Who provided the values to you?
Nobody provided the information, so I have no objections to those values, but the fact of the matter is that the defendant wasn't cooperative providing information.
Just how do you get the number 15 and 8? Blue book them or?
I did not blue book this, Judge. I basically, to be honest with you, I look up the value of a car on the selling site.
Okay, all right. So, okay,
We can leave it blank if he wants. I have no objection to that.
okay, Ms. McClure?
No position.
All right, we'll strike the value and just leave it as unknown.
I can't speak to the house value, Your Honor, other than it's my understanding he owns a joint with his wife.
We usually take that from SCV.
That was given to
By him? All right,
But I mean, it's a joint ownership situation.
right, but that, we'll leave that one as, because Mr. Jones said that's what Mr. Jones told him.
So as to any factual information, that would be it.
Okay. Anything you wish to object to, Ms. McClure?
No.
All right. Does the pre-sentence report, I show he has no prior juvenile record, no misdemeanor, and no felony record. Is any objection to that?
No objection.
All right, so we're back to the guidelines. So on file number 23-21221, we'll start with count 1, CSC first degree. The guidelines were calculated to be 108 to 180. I do believe the last time we were here, there were objections placed on the record. I'm not sure, or ability with prior counsel, but Mr. Malaro, do you object to those numbers?
So Judge, the only issue I have is on PRV 7.
Okay, hold on, let me grab my guideline book.
It just, I don't think it affects the grid. But on other, and maybe this is, I'm going.
Hold on one second, Mr. Malaro, hold on, let me get my book. Miss Adams, wasn't here, but sometimes I wander off of it. It's kind of an older one. Which one?
PRV 7.
Miss McGrain, I don't know if my newer one's on my desk. I must have taken it in back.
Do you want to borrow mine?
Judge, I don't know that you need the book for it.
Yeah, I don't think so either, but
I always have a
just
book,
so you
though.
have it. I know.
love this book.
I know.
Okay, so subsequent or concurrent felony convictions. I'm gonna switch back with you. Okay, what is your objection, Mr. Malone? Thank you.
It's not as much an objection as Judge, on the other offenses, PRV 7's been scored as 20. And then on this case, in the child abuse case, the PRV's been scored as 10. I don't think, I don't know if the other one should be scored 10 or this one should be scored 20. Neither way, it does not affect the grid. It's still a level C. But for the sake of accuracy, I think that should be clarified.
It's for 2 or more subsequent or concurrent, so I believe it should be 20 on all.
I would agree. This is clerical.
Okay, so then PRV 7 on all of these will be changed to 20. Okay.
Other than that, I have no issues with any of the other scoring.
Okay, and they don't change the guidelines. All right. Do you have any objections to any of the guidelines, Ms. McClure?
No.
Okay. And then, so count 2, criminal sexual second degree is 36 to 71. Child abuse second degree is 43 to 86. Those change though, right? No. And then second degree criminal sexual conduct, 36 to 71, no objections on those.
Correct.
Other than amending all of them to be 20 points for PRV 7. Okay, excellent. Thank you. Okay. So do we have someone who wishes to speak today?
Yes, Your Honor.
Okay, so could you have them come up?
Yeah, so just for the record,
Oh, and let me add real quick. Yesterday, a victim impact statement was handed over to Mr. Jones, I believe.
So that's not a victim impact statement. I think that was a statement of allocution on behalf of the defendant.
Okay. Okay, oh, yep. So anyway, did you receive a copy of that?
Does it start out, good morning, Your Honor?
It's by Bianca Sumner.
Oh, yeah, I did get that this morning.
And it's actually a letter in support of Mr.
Correct.
Thomas. Okay, all right.
We received that as well.
Yep, I did
reviewed
too.
that.
Yep. All right, so do you have
So,
some?
yeah, so Grace in this case has had a lot of trouble, both coming in and dealing with the case leading up to sentencing. She did make it here last time we were set for sentencing, and then it didn't go forward, and she just felt she could not make it in today. But she would like Miss Shananaquat to speak for her, and she did submit a victim impact statement, so I would just ask that she come up and read that on behalf of Grace.
So, Your Honor, after I spoke to Mr. Toms about that, we would have registered an objection to anyone other than the prosecutor or Ms. Trombley reading a statement. It's in writing. So we would register an objection to that. Other than Ms. McClure.
That's fine, Ms. McClure can read it.
No, well, I would just state my response to that objection would be that under the Crime Victims' Rights Act, under section 780.825, the victim, if she's physically or emotionally unable to make her statement, she can designate anyone over the age of 18 to make a statement on her behalf, and it does not have to be an attorney.
That is
That may be so, Judge, but I'm not aware. I mean, my understanding, this person's of age. I'm not aware of any disabilities that she'd be under that would prevent her from making this statement.
Well, I'm relating to the court sheet
Yeah.
that Grace has
Okay,
mentioned.
so I have a victim impact statement from Stella.
But the statement's from
Hold on.
Stella, not
Yeah,
from Grace.
so she can't read her own statement, but someone can read Grace's. Does Grace have one?
No, not that she gave to Stella. She wanted Stella to read hers on behalf of Grace.
Stella's reading Stella's statement. That's what
Correct.
our objection is.
And I think that's appropriate because it speaks to Grace's, how this case has affected Grace.
Well, it speaks to how Stella perceives how this case has affected Grace.
As an officer of the court, Judge, I've spoken to Grace. She knows what Stella wrote. She had a hard time. Grace had a hard time writing her victim impact statement. She did write something, but she did not feel it was appropriate to share with anyone. So she is asking that Stella read Stella's statement on Grace's behalf. And I think that's appropriate under the statute.
What's the statute number?
MCL 780.825.
780.825. Oh. Okay. Okay, so under subsection 1, if no pre-sentence report is prepared, the court shall notify the prosecuting attorney of the date and time of sentencing at least 10 days before the sentencing. The victim has the right to submit a written impact statement, and has the right to appear and make an oral impact statement at the sentencing of the defendant. If the victim is physically or emotionally unable to make the oral impact statement, the victim may designate any other person 18 years of age or older who is neither the defendant nor incarcerated to make the statement on the victim's behalf. The other person need not be an attorney. They can appear remotely. So if the victim is emotionally or physically unable to make this statement, they may designate any other person to make the statement on behalf. So I think that this person can make a statement. It doesn't say the victim statement.
It does say the victim statement, Judge.
It says the statement.
It says the court shall consider the victim's statement in imposing sentence. This is not the victim's statement. This is her friend's statement of how she perceives.
The victim may designate any other person 18 years or the age or older, who is neither the defendant nor incarcerated, to make the statement on the victim's behalf. So, let's see here, amended. Maybe cited as Rebecca Beischlaw. All right, so hold on a minute. Do you have any case law otherwise? Because I'm gonna have to go back and look real quick.
No, I don't have
Right.
case. I mean, I thought it was pretty clear. I'm sorry.
I do too,
Yeah.
but let's think. So let me take a recess.
Right.
You may be seated. So in matter of the people of the state of Michigan versus Waklowski, W-A-C, L-A-W-S-K-I, docket number 287146, 286 Mich App 634. This case basically supports that. She is requesting that this individual make a statement on her behalf. It doesn't need to be her statement. It can be her, the individual who's making the statement's own individual statement. So I think since she's requesting that this woman make the statement, we can do that. All right, so who is that individual?
Miss Shenaniqua, and I'm probably saying her last name wrong. But she was a witness in the trial as well.
Shenanigans, I remember this in trial. Ma'am, I don't, Mr. Malaro, there's a woman behind you trying to get your attention.
Do you need, you have a copy? Hold on, wait 1 second.
Hold on 1 second. Okay, so ma'am, for the record, state your name again for the record.
Stella Shenanigans.
Okay, and all right, I do have your victim impact statement, as do the attorney, so you may proceed.
My name is Stella Shenanigans. I love Grace Trombley like she's one of my own kids. This has been a long, horrendous journey for her. Those of us who care about her, the trip is done and we have to watch the aftershock. A parent's #1 job is to protect and love their children. Grace had the misfortune to be born to a woman who didn't protect her. This woman knew what was happening to her daughter and turned a blind eye. She went on to stand up next to the abuser and proclaim her love for him while cutting her daughter from her life and influencing other family members to do the same. These parents raised Grace in a home of strange rituals and ceremonies and neglect. She had to grow into an adult before she realized that her home life was not the norm. They attempted to blame religion for Doug's sexual abuse of Grace. They attempted to paint the case as some form of religious discrimination. When that long shot failed, they attempted to blame me. I met Grace years after these events and did nothing but love and care for her. I took her into my home when it was clear that her own home was problematic, and they left her there. They were so worried about my influence that not once did they speak to me about Grace, the circumstances of her living with me, attempt to support her basic needs while in my home, or in any way attempt to remove her. I taught her to drive. I helped her get her driver's license and first car. I guided her through the college admission process and helped her find financial aid to make her plan happen. I did a million things that her parents should have done, but these abusers would have people believe that I'm somehow to blame for the abuse that happened long before I entered Grace's life. I'll live forever with regret that although I knew something was very wrong at 444 South Main Street, I didn't know just how wrong and was unable to support Grace earlier in bringing justice to her abuser. I regret that I didn't somehow pull Grace and Douglas from the hell they lived in. I regret that I didn't look closer at these people and realize that they were far worse than the crappy parents I saw and were in fact monsters. Nothing will make Grace whole again. Her parents have made sure of that. But Doug has grandchildren. Because it's clear that Karen won't protect kids from Doug, someone else has to do it. A very long sentence, the maximum available for all charges, will make sure that he doesn't do what he did to Grace to another child. That long sentence will make sure that the next time he is possessed by a spirit, no other teenagers will suffer for it. A long sentence will keep the community safe from a predator.
All right, thank you.
Can we never spell her last name?
It is spelled.
I can email you.
I got it. Stella is her first name, and her last name is SHANANAQUET. UET.
UET?
UET.
Okay, thank you.
All right, anyone else?
No,
thank you. So, Ms. McClure, is there anything you want to say on behalf of the people?
Yes, just briefly, Judge, just that this court heard the jury trial and the testimony of each of the witnesses. It's reviewed the PSI, and I'm comfortable with what Stella has represented to the court today. I've been in close contact with Grace throughout this, and she's deeply affected by this, alienated from her family, and has been for some time, and she struggles with this mentally, and I think will for a long time. I do believe that the recommendation and the mandatory minimum is the appropriate sentence in this case, and I would just ask that everyone remember that the criminal justice system has played out so far. He, will have an opportunity at the next level, but at this case, or at this point, we need to trust the jury verdict and trust the testimony that we heard in court and sentence accordingly. And I think that, again, the recommendation is appropriate. I think what happened to Grace in this case, I agree with Stella that it took until she was an adult to realize that her home life wasn't normal. And I think that's deeply affected her, and the sentence should reflect that.
Thank you. All right, Mr. Malaro, is there anything you'd like to say on behalf of your client?
Yeah, briefly as well, Judge. As I said, this is, I'm in an awkward position as I'm not privy to any trial, pre-trial, anything other than this pre-sentence report talking to my client. But as the court can note, he has no prior record. He's 57 years old. He does have some serious health problems. I know that, and I've explained to him that the one offense he's going to have, is a mandatory sentence. And he understands that. I've also explained to him that he has a right to an appeal. Your Honor, Mr. Toms, to me, when I spoke to him and met with him, I was with him for about an hour. Got to, he seems to be a pleasant man. I don't know any of the details. The court said through the trial, he's been convicted. I know Mr. Toms does respect the judicial process and understands that whatever options are available to him going forward in the form of appeal, I'm certain will be taken into account in what he decides to do. That being said, Your Honor, we'd ask the court to find it to sentence him to as minimum time as possible.
Okay. Mr. Toms, is there anything you want to say on your own behalf?
Yes, yeah, I take issue with the fact that I did not get a chance to testify on my own behalf. And I take issue with the fact that I still had two witnesses that never got an opportunity to testify on my behalf. I would respectfully request a new trial with Judge Olsaker.
Which obviously would just object and say that's not appropriate at this time.
Okay, so Mr. Toms, those are appellate issues. So obviously you can address those on appeal because you have an automatic right to an appeal. Okay.
Yes, ma'am. Yes, ma'am.
Okay. And I know at the time of trial, you consciously made the decision not to testify. I know. All right, ma'am, if you're not going to sit still and behave, you can go sit in the hallway or you can sit still and behave.
I will.
Thank you. So, so obviously those are all appellate issues and we'll get to you at the jail, your notice of right to appellate review, and then I'll give you the instructions on how to pursue that. Okay.
Yes, ma'am.
All right. Is there anything else you want to say?
There's one. I'm sorry, I forgot. Mr. Toms, while in custody, has been victimized by a scam. I know that I told him it does not have much impact as to how this court can proceed to sentencing due to the mandatory sentence requirement. But he was victimized by people at the jail where they extorted and blackmailed considerable sums of money from him and his wife. And so he has already paid a severe price for what has occurred here.
Okay. Well, obviously that the proper recourse for he and his wife would be to file a police report and pursue that. Okay. Anything else?
No, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. This is, as I said, a conviction based on a jury verdict after a jury trial. It is a sentence of the court that on count 1, CSC first degree, there is a mandatory sentence on that, and that is a period of 25 years to 50 years with the Michigan Department of Corrections. We'll give you credit for 105 days. There is a $130 crime victim rights fee, $68 in state costs, You're required to remain active on the Michigan Sex Offender Registry for life. And to be on electronic monitoring for life upon release. You are to have no contact with Grace Trombley directly or indirectly, and you will receive, as I said, credit of 105 days. On count 2, criminal sexual conduct, 2nd degree, you will serve a period of 5 years, 11 months to 15 years with the Michigan Department of Corrections with credit for 105 days already served. On count 3, you will serve a sentence of 5 years, 11 months with the Michigan Department of Corrections to 10 years with credit for 105 days already served. And then on count 4, criminal sexual conduct, 2nd degree, you will serve a sentence with the Michigan Department of Corrections of 5 years, 11 months to 15 years with credit for the 105 days. So there is a $68 state cost for each count, so 68 times 4, but there isn't only one $130 crime victim rights fee. There's a DNA fee as well.
Yes, sure.
There is a $60 DNA fee. On all counts, there's to be no contact with Grace Trombley, directly or indirectly. Anything else, Mr. Jones?
Just with sentences run concurrently.
Yes, I'll have the sentences run concurrent. Anything else, Ms. McClure?
Just because I know it's been missed before, I just want to make sure we're clear in the lifetime electronic monitoring. Okay, thank you.
Anything else to add?
No, Your Honor.
All right, so Mr. Toms, we're gonna send over to the jail 3 copies of your notice of right to appellate review. They're gonna have you initial and date 1 copy just to acknowledge you received the paperwork. That'll come back to me and it'll go in the file. The other 2 copies are for you. You can fill those out today and they'll process them back over here, or you can send them from MDOC. But if you intend to appeal, you might as well do it today. That way it comes directly to us. You would fill out the information on the appeal form and then just tell them you want it sent back to the court, and then we'll send it over to clerk's office. All right?
Thank you.
If you don't do it today, you have to do it within 42 days, which is why I'm saying it might be easier to do it today if you plan to than trying to do it at processing. All right?
Yes.
All right. Very good. Anything else?
No, Your Honor.
All right. That concludes our docket for today. Thank you. Mr. Jones will get me updated. Oh, no, never mind. Oh, we gotta change the scoring on here 7, so, okay. All right, very good. Hi, Mr. Malaro.
Thank you, Judge.
I just want to wait a minute if that's okay.